Hello everyone, this is Mahek, a legal internet LEXIS and Company. Welcome back to our channel. Today's topic of discussion is force majeure clause under contract act, or we can say in any contract or agreement. What is this force majeure? A force majeure is a wider term than vis majeure. Now you would wonder what is this vis majeure? Vis majeure means act of God. Anything that is not influenced by human activities, anything that is not controlled by human or that cannot be prevented by means of any by means of taking reasonable precautions, etc. The acts of this nature includes like earthquake, any natural disaster, flood, drought, heavy rainfall. These all are the acts of God and cannot be prevented by taking any precautions. Nobody can prevent a earthquake. No one can prevent. No one can take remedies against heavy rainfall, unnaturally heavy rainfall. So these all are the acts of God, and they are sufficient to to frustrate the object of a very contract or to discharge the contract, as the performance of the contract would be impossible when such events exist. So now, what is this force majeure includes? First thing, force majeure includes act of God. Act of God's all the things like earthquake, natural disaster, etc. Force majeure includes these things. Besides these things, force majeure also includes acts like human activities but that are beyond the control of an ordinary human. For example, strike. For example, breakdown of a machinery, or we can say have strike, we can say breakdown of a machinery, sudden sudden rupture of a house, sudden fall of a house, or anything, or such activities that are not said to be done by act of God. They are not completely done by a act. These are in the hands of a human being, but these are not contemplated by the contract party. I'll discuss it later. So the acts like strikes, breakdown of a machinery, rupture of a house, or rupture of a bridge, we can say, or act of God, and also act of God. These all acts frustrate the very are able to frustrate the very object or very nature of the contract. So these are the force majeure. So these are the things included in the force majeure. Now, how this force majeure when this force majeure would come into play? When there is any official contract, say there is a contract between two parties for the construction of a marriage hall. The party said they want marriage hall in within 2 months. There was this construction work going on the marriage hall, and the owner of the hall and the owner of the banquet hall said that yes, that the construction work would be completed or concluded before the marriage, and you will get this hall as per your needs. So while contracting this, they decided to contract this through an official papers. They signed the contract, and in this contract they attached the force majeure clause. What is this force majeure clause? That it is from the side of the owner, and it is written in that clause that if if certain exigencies, if certain force majeure occur, force majeure means the acts of God or strikes or anything that are not in my hand, that cannot be contemplated by me. So these things, so force made so these if such acts like strikes occurred or anything would be happen, then he would be responsible for the same. So if it is signed, the contract is signed by the uh, by the by the by the other party, then it would be assumed that then the other person, or we can say the acceptor, that it means the acceptor have agreed to the force majeure clause. So what happened now, if the workers or the laborers went on strike due to non payment of the salary, and this strategy of, we can say, of labor union was not in the knowledge of the owner of the hall, then he can plead that, and if on non completion of the this reconstruction work of this construction work. The 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 other person who wants the hall for the marriage would can sue the owner of the house because the hall was not ready, and now he cannot use it for 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 the purpose as mentioned in the contract. Means the contract was means the contract was breached by the owner. Then in that suit the owner can claim the defense that the act of the laborers was a force majeure. And a force majeure, why? Because they went on strike, and that strike was not in contemplation of him, so he cannot claim that he knew the that strike would be that they would went on a strike which would halt the work. So he cannot be blamed for not performance of the marriage on the very day due to the incompletion of the work. So the other person cannot say that no, I don't know this the strike. He must have known this than that, because he has signed the force majeure clause. He has signed the contract including the force majeure clause. He cannot now sue him, or he cannot claim the maintenance if provided if he could prove provided if he failed to prove that the strike was known to him, known to the owner. So the force majeure clause, or we can say the defense of force majeure, would be available to the contracting party from whom the breach was given, from whom the breach occurred, only if the other party had signed the force majeure clause in the contract. A force majeure defense won't be able to either party if it was not included in the contract. Force majeure per se is not a defense unless and until it is mentioned in the contract. An act of God is a per se defense. It does not need to be mentioned in the contract that I would be taking a defense of act of God if earthquake occurred, and if some heavy rainfall occurred, or if that was reason I won't be able to complete the work, or that would be the reason I won't be able to perform my part of consideration. So then in that case it would be an absolute defense of act of God. But for force majeure, it is a requisite that both the parties must have signed that clause included in the contract. If they have not signed, then the owner of the hall will not be at liberty to take the defense and the strike was a force majeure, as I didn't knew that that they would went on strike. So in that case it would be the plaintiff who claim for damages would be the one who would be the winner party. But in the presence of force majeure, he cannot claim for compensation, and he has already signed the force majeure clause. So I hope I am able to make you understand about the force majeure clause of a contract. Hope you like this video. Do like, share, and comment your views in the comment section. Thank you.